As each October rolls around, the U.S. Supreme Court also begins a new term. And this year, they're facing some very important cases. So what are some of those things that we're tracking, some of those issues that are on the Supreme Court's docket for this upcoming term? And how will those affect American families? Well, here now with his insights is Josh Hammer. He's a senior counsel at the Article 3 Project. Josh, welcome back to Washington Watch. Always great to have you.
Congressman, it's always a pleasure. Thanks for having me.
All right, let's start with this. Before we start looking at some of the cases that the Supreme Court is going to be hearing, what are some of the cases that it declined? Some of those things that probably some of us thought that they would take up. I'm thinking particularly of the Texas hospital case and the Alabama IVF case.
Yeah, you know, that Alabama IVF case got a lot of headlines back in February. I actually wrote my weekly syndicated column on that very topic back at the time. But what was lost in the weeds was that while this is obviously a politically and in some ways morally fraught issue, IVF, that particular case was actually a very straightforward case of statutory interpretation. So essentially, just real quick, what had happened then, the Alabama Supreme Court and the Alabama State Judiciary had uninterrupted interpreted its wrongful death of a minor statute for a very long time to hold that when the statute talks about child and children, then unborn child and unborn children are included there. So all the court had to do was to not legislate from the bench and to read in an extra utero exception whereby the legislature had not done that. Now, the Alabama legislature actually subsequently then added that in, Jody, but it's not surprising to me that Congress actually did not, or excuse me, that it's not surprising that the Supreme Court did not step in there, given the fact that legally speaking was actually a fairly straightforward case. But I understand that a lot of people are probably surprised as to why they do that. It's just a reminder that the court doesn't necessarily step in every time there is a politically or morally charged issue. Rather, they only do so when there are very clear conflicts of interpretation and that there is a legally interesting case at hand.
Okay, interesting. Good insight there. Okay, so moving on to the cases that the Supreme Court has decided to take up, a case involving gender mutilation procedures on children. I think all of us anticipated this. I mean, that one was destined to get at the Supreme Court eventually anyways. And many people are going to be tracking the case concerning Tennessee's law protecting minors from transgender mutilation surgeries. Tell us about this one. What do you anticipate?
This is definitely the money case from my perch, from where I sit. This is probably the single biggest case of this term, the same way that the Dobbs abortion case was the biggest case in the term ending in 2022, and then the affirmative action case was the biggest term of the term ending in 2023. So the transgender, so-called gender affirming care case, this is definitely the marquee case. So it does come out of Tennessee. They have an exceptional attorney general there, Jonathan Skrmetti. And the Sixth Circuit, the U.S. Court of Appeals for the Sixth Circuit ruled the correct way in ultimately upholding Tennessee's ability to regulate, if not outright ban, if they want, genital mutilation for children. Now, the other side is making a 14th Amendment equal protection clause argument. They're essentially arguing that transgender status, the gender identity, is a constitutionally protected suspect class under the 14th Amendment, the same way that the Supreme Court has in the past held that various other classifications along racial or sexual lines get you either strict scrutiny, intermediate scrutiny. So they're basically saying that this gets heightened scrutiny and legalese, and therefore a state cannot regulate it unless there is a truly compelling interest. As you and I know, and as anyone with any common sense knows, you really don't have to be a lawyer to know that this is total bumpkin. That's not how it works, because in reality, for thousands and thousands of years, we have always known that there are two sexes in humanity. There is male and there is female. We know that from natural observation. We know that from just empirically observing the way the world works. We know it from Genesis 1:27 as well. We know that every which way we can know it. And Tennessee is well within its rights to regulate, and if it wants to outright ban genital mutilation and chemical castrations for minors, that it can do so. I'm actually fairly confident that the Supreme Court is going to do the right thing here. I never want to get too ahead of my skis, but as far as constitutional law goes, I think it's a fairly straightforward case. I'm optimistic about this one.
Well, let's certainly hope so. Another case is Texas age verification law for websites with sexually explicit content. What precedent do you think we could see there, maybe?
So I'm optimistic about this one too, but maybe not quite as optimistic as the other one. You know, it's funny. I typically am pessimistic about the court, so I'm kind of surprising myself when I say that I'm so optimistic about some of these culturally and morally charged cases there. But historically speaking, I mean, this is kind of just federalism, constitutional law 101. And of course, Jody, you served in Congress, so I'm preaching to the choir here. But the Congress has specifically enumerated powers under Article 1, Section 8 of the Constitution. There are 18 clauses there, so they have the power when it comes to militia and raising money and various other things. And the traditional view is that the police powers reside in the 50 states. And the traditional way that the police powers were viewed was to regulate the health, morals, and safeties of their respective populations. Those are really the three big legs of the three-headed state police power stool, you might say. I cannot think of something that more quintessentially fits the state police power, if we even still believe in something like a state police power in the 21st century. But if we believe in it at all, surely it's going to apply to the ability of Texas to implement an age verification for pornographic websites. Now, the Supreme Court case law on the issue of pornographic websites is kind of hit or miss. So there was the ACLU versus Reno case from the late 1990s, which was a ruling that redounded, unfortunately, far too much to the interests of the pornography industry. But I think that this current court stands in a good position, or as good a position as any, to start to slightly pare back the ACLU versus Reno ruling and to side with Ken Paxton in Texas.
Well, it's going to be interesting to me how they decide on this, and then you weigh that up against the pornographic books in libraries and schools that are being used for children. This has to enter into the long-term debate on all of this. So very, very interesting how all of these cases, I wish we had time to get into some more, but thank you so much, Josh Hammer. Always great to have you giving us your insight and great work that you and everyone there at Article 3 Project do. Thank you for joining us today.
I really appreciate it, Congressman. Thank you.